All right, we're going to go ahead and get started. Thanks for coming out today. We're going to start with Sheriff Travis Patton. If you can come on up to the podium up here.
Good evening, everyone. First of all, I want to thank you all for allowing me an opportunity to speak on behalf of Marcias Law today. And I also want to just take a moment to thank the Lord for allowing me to be here as well as an advocate for such a just cause. As you know, it's already in the Constitution, and you already have the Mississippi Crime Victims Bill of Rights, and that was put in place a long time ago. But times have changed, and so have people. People have changed. Now, if you look across America right now, you have all kinds of pushes for people who have the desire to be treated as equals. Right now in our bill, and I'm grateful for the legislators of this state for passing the bill that they passed back then, but I'm here as an advocate to tell you it's time to amend it, change it, and put some new things in effect. When you look at the old bill, it tells you about three major categories that are covered when it comes to victims being notified. You're talking crimes which involve physical injury or threat of physical injury, any sexual offenses, and any involvement spouses of abuse and domestic violence. In today's times, that's just not enough. I think we have a new way, a new thing that we're trying to do here in the state of Mississippi to show not only our constituents that we've changed, but the rest of the world as well. And that's just too narrow of a scope. When you leave those victim notifications just to those three categories, you're leaving out all other felonies that leave people feeling extremely violated when it happens to them. Think about a property crime when you've been out on vacation and you come back home and everything's gone. Nothing's there.
Yes.
This is Cliff Johnson. If anyone's speaking, I apologize for interrupting. I can't hear anything over the Zoom. I wanted to make you aware of that.
Would you try to...
Testing.
Is that better?
Testing. Testing. Can you hear me? Testing. Testing. Testing, testing. Can you hear me?
I can hear you. Thank you. Perfect.
Good deal. Thanks.
All right.
Thank you.
Judge Cassell, can you hear?
Yes, thank you.
As I was saying, though, with just these three categories, it leaves a whole nother group of people that's being excluded from victims' rights. Right now, we see all kinds of laws being changed and enacted on behalf of the criminals. But I'm asking this legislative body to consider improving on what you already have in place for the victims. If you think about juveniles and the crimes that juveniles commit, right now, even in our county, the majority of the crimes that are committed are from juveniles. But there is no system in place, no checks and balances to make sure that the victims get their proper say in court or the proper notification in court. And it's not just that, though. We need uniformity around the state. Right now, what we had to do in Adams County, we had to get a crisis intervention team in place because it was so many people not being notified of cases, so many cases getting dismissed because of these notifications that we had to go and hire three people to make sure that victims were walked from point A to point Z through the judicial system. And I know everybody doesn't have the money to do that, the funds or the abilities to do that. But that's what we felt like we had to do at home to make sure victims had their say as well. So I'm not saying that the state of Mississippi did anything bad in this Mississippi Crime Victims Bill of Rights. I'm saying just as times have changed, people have changed, and we have, it's time for us to improve on this as well to make sure victims of crimes, period, have their say, have their voice, and that we put some teeth in the notification process as well to what needs to happen to make sure these victims have their day in court. It's too many times I've seen deals worked out behind the scenes and victims' families calling me feeling like they were left in the cold and didn't have their say. By putting Marcias Law into law here, that would eradicate that and change that. And I know there's several people over there who's going to speak on that, but I wanted to come from a sheriff standpoint to let you guys and you ladies know that I stand with the victims and I stand in favor of Marcias Law for this state.
Thank you very much. Does the committee have any questions? All right, Senator Super.
Sorry. Thank you, Mr. Chairman. Sheriff,
Yes.
do the district attorney's offices now, most of them I deal with have a victims assistance coordinator that works with the victims, and just about every case we've dealt with, they contact the victim before any deal can be reached. Is that not the case around the state?
They have victims coordinators, but there's no checks and balances in place to make sure they're doing their job as well. And that's why we had to get a victims coordinator at our own agency to make sure that the victims were getting the proper notification of whatever benefits or anything that they could receive. And that was a problem for us because, to be honest with you, as 5 years as sheriff prior to the new district attorney getting in office, becoming a DA, it was rare that we seen them unless we went over and tried to make contact, and that shouldn't be the case.
Well, I was looking at the list. I don't see anybody from the district attorney's office. Well, we have the attorney general's office, but I mean, I was just wondering if that's something that we could do, to maybe help fix that gap. Instead, I'm not against this or anything. I'm just just wanting to clarify.
And I understand that if you read the bill that's currently in place, it says they are to be notified. It doesn't say shall, and it doesn't put teeth into who should do the notifications. And I think that's one area that we can definitely shore some things up with.
All right, thank you.
Any other questions? Yes, sir. Senator Simmons.
Sheriff, thank you so much for your presentation. As a follow-up to Senator's question, are you saying that your issue or the notification issue you just explained to this committee was an issue with the former district attorney's office?
It was, but the current district attorney's office with us, and I'm just speaking in Adams County when I say that, but if you go, I guarantee if you go to all 82 counties, you're probably going to get a different answer on that. It needs to be some type of uniform structure across the board on who's responsible for notifying these victims. Because right now, if you look at it, it says they are to be notified, but it's not saying who and things of that nature. It needs to be some teeth in that part of it for sure, because I've seen too many cases where they've either been dismissed or continued and the victims have no clue, or a decision is made and then they're coming to us looking for answers as to how this happened when they should have had that voice ahead of time.
Just one or two follow-up questions. Who is your current district attorney for Adams County?
Right now, our current district attorney is Shamika Collins.
Who is your current senior circuit court judge for Adams?
That would be Judge Lily Blackman Sanders.
Have you addressed any of your concerns that you asserted today with any of those individuals, your district attorney or your senior circuit court judge?
Yes, I've discussed them with the DA's office, and that's why I said in the past only in Adams County, because with the current DA, we actually meet monthly.
Okay.
We meet monthly.
And you've also, with Judge Blackman, you've also addressed it with her?
No, I have not addressed it with Judge Blackwell.
Okay, thank you.
Any other questions? Thank you very much. Next, we're going to have Judge Maria Del Mar Verdant with Marcias Law.
Good afternoon, Senator, committee members, Chair, Vice Chair. Thank you for giving us the opportunity to be heard today. Forgive me for wearing a mask. I come from Arizona, and I stopped in Dallas on the way here, and I don't know what I'm bringing you. So in an effort to bring to keep some unwanted guests from being here with you, please let me know if you can't hear me. I'll do a better job of getting closer to the microphone. Before I begin, I want to let you know that Ms. Hicks is here, Fontella Hicks. I asked her to come, and I'm going to yield some of my time to her because I believe that you hearing from someone who lives in Mississippi and has experienced the rights as a victim in Mississippi is something very important for you all to consider. I also need to thank and make you aware that Mike Jones is here and his son Jacob. They are survivors as well, have been affected. They're sitting in the back of the courtroom. Oof, here goes. I've been a judge for a long time. They are here also to support Marcias Law, and I encourage all of you, please, to take a moment to speak to them to see if there's something that they may have to contribute as you mull over this discussion, whether or not this is something that you want to see in your state. Thank you to Sheriff Patton who made the trip here, and I want to say that Sheriff Patton illustrates the kind of support that we have had across Mississippi. Correct, Senator Simmons, there are some folks that still have not been spoken to, but we are continuing with that cause. And I will tell you that 2 years of working in Marcias Law throughout the state of Mississippi has rendered a wide support. In fact, it resulted in the creation of House Current Resolution 35, which, as you all know, passed almost unanimously with bipartisan support in the last session. That was created by people in Mississippi, and it was for people in Mississippi, including the wants and needs of people that we communicated with throughout that process. I want to make clear that that is not a template. It is the creation of a unique body of language that serves the needs of the people of Mississippi. Having said that now, I want to introduce myself. My name is Maria Verdeen. I am the Senior Policy Counsel at Marcias Law. Well, I'm not comfortable speaking to you standing here. To be honest, for the past 20 plus years, I sat where you sit. I controlled what happened in my setting. I got to ask the questions. I got to decide what was relevant or not relevant. So I'm very humbled now to be before you and hoping that you will be able to listen to what I have to say. I try to take comfort in the fact that you, like I did, are public servants and listen to what people have to say and make a concerted effort to hear everything before you make up your mind about what you want to do. So that is my comfort today, standing before you in this humble position. My experience as a judge is important, and let me tell you why. I'm not here as a lawmaker. I'm not here as an attorney who practices. I'm not here as someone who is an academic who talks about how the law could be, might be, hypothetical situations. I'm someone who has lived and breathed in the courtroom, both as a public defender, as a prosecutor, and a judge, ultimately as a judge, on how these rights play out day to day in a courtroom. In Arizona, we have had victims' rights in our Constitution spelled out since the 1990s. So I'm going to focus on 2 key points because I have been encouraged to focus on policy, and that's what you all would like to hear. The first is, why amend the Constitution? Why can't this particular fix be done by statute? Already, Mississippi has a Victims' Rights Amendment in your Constitution. I don't have to cross that hurdle with you all because somebody wiser and earlier than me came to your state and decided that that was something important, and that was a basic tenet, a basic belief that you believed should be enshrined in the Constitution. But what we have learned since that Amendment came into your Constitution is that there are ways that it could be improved. And this is not new to Marcias Law. You know, this started in the 1980s when President Reagan put together a bipartisan task force that ended up making recommendations to Congress on what the law should be. And there are states throughout the country who have implemented specific victims' rights in their Constitution. And they play out, and there is a wide body of case law throughout the country on how this works. What Marcias Law brings to Mississippi is the following. It's going to define victim. It's going to expand the ability to have these rights applied to victims who are in the juvenile court, because quite frankly, if I'm attacked by someone who's 15 or 55, it really doesn't make a difference to me. I want to have my voice heard, whether it be in the juvenile arena or whether it be in the adult arena. Empowering the victim to opt into being notified, having information about a hearing, and having information about release. An opt-in is very important, and let me tell you why. Because we can't presume to know what every victim wants. We need to empower a victim. Some victims want to be very involved. Some victims don't want to be involved at all. Some victims want to advocate for the defendant. And you know what? It's their right, and they should be able to do that. So this is a right that clarifies that there is a provision to opt in if you want to, and opt out if you don't. You don't have to opt out. You can opt in. Identifying the hearings to be heard. So there is a certain set of hearings where you should have the opportunity to be heard. They are defined and should be spelled out in the Constitution. Considering the safety of the victim and making that key in the decisions that are made throughout the criminal justice system. And most importantly, standing to enforce. What Mississippi has now, if you read it, is less than 50 words. That is a vague collection of language, does not spell out rights. What it is a provision that authorizes the legislature to create laws. And so that can change, just like you and I come and go. The fact that the legislature can change laws through statute means that it's not something that is enshrined and solid and consistent and protected in the Constitution. So, again, why not statutes? We have a hierarchy of laws, and we all know that there are local laws, and then there are statutory laws, and the laws that we value the most and believe that should be the most, embody what we believe as Americans to be tenets, our beliefs. Those belong in the Constitution. And so that's where we have our right to vote, and that's where we have our freedom of religion, and that's where we have our right to bear arms, and that's where we have our protections for the accused, and that's where they belong. And we're not advocating that they should be changed in any way, shape, or form. A victim's right belongs in the Constitution. Again, I don't have to cross that hurdle. Mississippi already knows that. What Mississippi could benefit from is having those rights spelled out. Until you are able to assert your right, you cannot enforce it. And let me go back to that issue about enforcement and standing. A victim is not a party in the case. A victim only has standing because you're giving them the authority to have standing, to assert those rights, and to have those rights enforced. And so, in order for that victim to assert the rights and get the only remedy they have, which is participation, that's the only remedy, they have to be able to do that in the moment. Once that opportunity passes, it's gone. So it's not like a defendant who can appeal a decision after the case is gone. With a victim, unless they have the opportunity to raise their hand and be recognized by the court, they will never have that opportunity once it's gone. Why? Because double jeopardy attaches once the trial has started, once the trial is over, and we don't believe that defendants are tried twice. And that's what we believe as Americans, and we at Marcias Law uphold that. A constitutional provision will set forth a clear direction and expectations for the court, for the criminal justice system. You don't have to guess. You don't have to wait for it to be litigated like has been in some other places. It very clearly tells you from the get-go, you have the right to assert these enumerated rights, and you have the right to have them enforced. What does that do? That puts everybody on notice. That puts the judge on notice. That puts the prosecutors on notice. That puts everybody. You've got to be on your best behavior. I can tell you that as a judge, I bent over backwards to make sure that due process happened in my court. Why? Number one, because the Constitution demanded it, and I was sworn to uphold the Constitution. And number two, I didn't want that case coming back on appeal, because that would be tragic for everybody involved, all the players. So we do our best to follow what is spelled out and clearly gives us guidance on how things should be. Second point, and again, I'm trying to be brief because I know I don't have a lot of time, and I want you to hear from Ms. Hicks. There is a misconception that Marcias Law is somehow going to take away from defendants' rights. I can't tell you that that couldn't be further from the truth. Giving one person rights doesn't mean that you're taking them away from another person. Giving someone equal footing or leveling the playing field doesn't mean that you have exact rights for both. The victim doesn't have the same exact rights as the defendant. What it does mean is that you have equal access to justice, that you have an equal opportunity to be heard by the court before the court makes a decision. A victim should be more than a public spectator in a courtroom. A victim should be able to be a participant and be able to have the ear of the court. In this respect, I want to point out that both the defendant and the victim are before the court in a government action, and you want to prevent the government action from overreaching. They both are asserting rights before the court, a criminal justice proceeding, with the opportunity to be heard. Right now, we are not giving that right to victims. Rights have coexisted in courtrooms all over the country for decades. They coexist now in all 50 states in the federal system. And so I can tell you that in my courtroom and courtrooms around the country, defendants get acquitted every day. Because if the proof isn't there, if the burden isn't met, absolutely someone who's accused should be acquitted. And so giving a victim a right doesn't mean that a defendant loses their rights. These rights can coexist, and judges are very good at balancing and weighing, analyzing, and do it every day. The point I'm making is that Mississippi is not going to be an experiment. There is already a body of law to guide and implement how it is being done. Let me yield some 5 minutes or so to Ms. Van Teller-Hicks. She has a story to tell you, and she's worked very hard to make it brief. I have told her about our time limits. And so I would ask you please to give her your attention. She is going to talk about how victims' rights have played out for her in Mississippi. So I will come back to you as soon as she's done. Thank you.
Good afternoon. Members of the Senate and committee. I appreciate the opportunity to give insight on how, if Mississippi had Marcias Law in place, how it could have helped my family as a victim of domestic violence. My story in short. On July 22nd, 2007, in Jackson, Mississippi, at my mom's home, my ex-husband kicked in the door and came into my mom's home and assaulted me. After leaving the hospital for my injuries, which I had a concussion and had to get stitches in my face, I inquired with the police trying to find out if he was arrested. Couldn't find out that night. It was probably a couple days later, I got a phone call from St. Dominic's, and it was him. He accidentally called me. Then that's where I found out where he was at, by him accidentally calling my number, or purposely, I don't know. He hung up when I recognized his voice. So I had to jump through hoops and hurdles to even get charges pressed against him. Nothing was done. And I wasn't getting any information from the police department or anybody on what was going to be done. Fast forward to August 24th, 2007, a whole month later, without any info about my rights or him being formally charged or arrested. It was about 11:30 at night. My ex-husband broke into my home then, and he came this time armed with his own knife. He didn't have to look for one like he did in my mom's house. And he stabbed me over 35 times. And I don't really know the number because the doctor said he stopped counting at 35. So the previous time my daughters were 15 and 4 years old. Well, my 4-year-old, her birthday is August. So she had just turned 5 years old. She witnessed her father stabbing me repeatedly. My 15-year-old daughter tried to help me, and he told her, if you don't stop helping your mom, I'm going to kill you too. So that night, I coded several times. After being in the hospital approximately 8 days, I found out some weeks later, again, he was not in jail. Nobody informed me. I had to get my family to take me down to Circuit Court's office in a wheelchair to get someone to go in the basement, make copies, and get records. So that's when I found out the district attorney at the time had signed for his release and his attorney, but nobody notified me to let me know as a victim that he's not in jail again. And he was released to a alcohol and drug treatment facility. But the little bit that I do know about that is that even though he was ordered by the judge to go there, he can get up and walk away anytime. The only thing that they could do is call and notify that he's left. They can't hold him there. So after that, trying to call back and forth, and I was just being dismissed on everything, I called WLBT and did a report with a reporter, and after that, they put him in jail then with no bond. Trial was set, but he wanted to make a plea agreement. That's when I actually did talk to the district attorney at the time about the plea, and I agreed to the 20 years because they told me he had to serve 85% of his sentence because it was a violent crime that occurred twice. When he was set for sentencing, I wasn't even notified in a timely manner regarding victim impact statement, so I had to make a statement off the top of my head without even writing anything down because at that time I had paralysis in my dominant hand, which is right hand, and then I didn't have use of my left hand either because of injuries to it, and I had just had another surgery. In addition, I wasn't informed that restitution could be ordered, and I needed that help because my house was in foreclosure because I wasn't able to work, and he was in jail. And he had assets at the time that could have helped me with that, but nobody informed me of that. He served 9 years, and when he was released, I received a text message a week before his release from prison. No notification regarding release prior to him going to release to speak before the parole board about my concerns and about his release and where he was going to be released to, nothing. That's my story in short. So I've told you my story with a few points, and so let me tell you a few points on Marcias Law rights that I think that could have helped my situation. The first one is the right to reasonable protection from the accused. And that would be not somebody standing at my door 24/7, but at least somebody letting me know he's not in jail. So I could leave my home or not be where he can get to me again. The right to be informed of my constitutional rights, the right to reasonable and timely notice of any proceedings involving criminal conduct, the right to be heard in public proceedings, the right to reasonable notice of any escape or release, the right to reasonably confer with prosecutor and be told the truth, the right to have restitution. Now, I know a lot of you feel like that it's enough that's written about for victims' rights, but it's not, because right now as it stands, the police departments, the DAs, even judges, they just kind of do what they feel and what they're told a lot of times. And I can't concretely point fingers at people and say, but if somebody lets somebody out of jail that they know that tried to kill you and don't inform you, that's all you caring about is his rights, not mine at all. And so I want it to be where these people have to be held accountable when they don't do their jobs, or it got to be somebody's job. It can't just be sitting there and say, yeah, it's here, these are your rights, but nobody enforces it, and you don't even know what your rights are. As I said before, the rights were not enough for me and my girls, and this crime devastated me physically, mentally, and financially. And I didn't have any recourse. Well, I had some recourse, but I wasn't told about my recourses. That's the whole thing with me. And in closing, I'd like you to consider the victim perspective and message you send to survivors like myself across the state. We need our rights strengthened, and all I'm really asking is that you vote to put Marcias Law on the ballot and give Mississippi voters the opportunity to consider the issues and decide for themselves. Thank you.
Thank you, Ms. Hicks. Y'all prepared to answer questions?
For her or
For
me, sir?
either one, both. Does the committee have any questions for Ms. Hicks or Judge Verdon?
Thank you, Mr. Chairman, and thank you, Judge, and thank you for sharing your story with the committee. I actually have some questions for the judge.
Oh, okay.
Thank you, Your Honor, for making the trip to be with us today. I have a question about just how this works in practice in the states where it has been enacted, where Marcias Law has been enacted. Once the prosecutor evaluates the facts and circumstances of a case, he goes through and figures out what elements of which crime are met, and he then moves forward with the prosecution. How does letting the victims participate in those early stages of the prosecution, how does that work to help enhance the prosecution of the case?
From a prosecutor's perspective?
Yes, ma'am.
Yeah, okay. Well, I think the line of communication between the victim and the prosecutor has to be there. You know, as a prosecutor, I had to speak to my victims. I had to have that communication to know, is there something I'm missing? You know, does the police report, is it consistent? When I'm evaluating the facts on whether or not the elements of the crime are there, whether or not to charge. It empowers the victim because at least they understand the process. So in the early stages, you're talking about pre-charging, sir? Before?
Pre-charging and then the early, I guess, you know, what you're talking about, I think we're talking about the investigation portion, or when the prosecutor first gets the file and he's going through and evaluating the case.
So the police submit the report, prosecutor gets it, prosecutor decides whether or not the elements of the crime are there, and then if they decide to go forward, the victim advocate or the prosecutor in some smaller counties, in Arizona, we have some very smaller counties where the prosecutor is the one who has the direct contact with the victim, maintains the contact throughout the case. So your question is, how do they continue to be notified, sir? Or
Well, how does it enhance the process? How does it help the prosecutor do his job? Because I've got a concern about some of the language that we're going to let the victim participate. The crime's happened. The defendant's been charged. with what the prosecutor is considered to be his best chance at getting a prosecution under the facts. Once we're there and we're in, then we've got the defendant's rights to be concerned about. If the victim's involved in that early stage of the prosecution, I don't know that I agree with your statement that the victim's rights and the defendant's rights can both be maintained if you've got the victim participating in the prosecution, but then under this law as written, the victim can have the right to refuse an interview, deposition, or other discovery request made by the accused. So I've got the defendant I've got the prosecutor who's already doing his job. Now I've got the victim I'm a civil lawyer, so for lack of a better term, the victim is becoming a party in the case, but then that party's not subject to cross-examination by the defendant?
Civil and criminal are two different animals, and I know you know that. So thank you for your question, and thank you for giving me the opportunity to go over what I think you're asking, and if I'm not, please redirect me.
And I'm probably asking a very poor question.
Let me make clear. Prosecutor drives the bus, okay? Prosecutor drives the bus and decides whether or not this crime is going to be prosecuted. And sometimes that requires me as a judge or a prosecutor to be able to look at the victim and say, look, the penalty for this is not crucifixion, okay? The penalty for this, the elements of the crime are not here. And so it's accountability on the part of the government to be able to look at a victim in the eye and be able to say, I'm not accepting this plea agreement for this reason. I am accepting it because it's in the interest of, whatever the case may be. Getting to your question about deposition and interviews. This isn't really new to Mississippi. In some states it is, but in Mississippi there's already case law, and I can give you case law citation, that says that a defendant doesn't have the right to compel an interview pre-trial. Not your right, I'm not talking about right to confrontation because that's a constitutional right. I am talking about a deposition, an investigation or information that happens before the case actually opens and goes to trial. So the reason that is in there is because there have been many abuses, and I'm not saying every criminal defense attorney does this, but guess what? If you harass the victim enough, the victim might not show up to court. This happens every day in domestic violence. How many prosecutors have been frustrated because the day of trial, the victim doesn't show up? There have been cases where they have been interviews for hours of victims on subjects that may or may not be relevant, and victims are powerless to stop it, where you can subpoena records, health records, medical records, psychological records that may not be relevant, but they have the authority to do that. Marcias Law, there's nothing stopping, Marcias Law that does not stop a defendant from approaching the court and saying, Judge, you know what, I think there's these Child Protective Services records that I think you need to review in camera because I believe that there's information in those that would be helpful to my client's defense. And at that point, the court weighs it and evaluates it and maybe does an in-camera inspection and redacts things or says there's nothing there. So it doesn't stop the defendant from actually being able to ask the court for relief, but it does stop them from being able to willy-nilly say, I am going to compel you to show up for this interview. Did I answer your question?
I think it's in there somewhere, yes, ma'am.
Okay.
But I appreciate it, thank you.
So,
Thank you, Mr.
you know, to answer more thoroughly, what I think Mississippi has right now is a placeholder. There is a placeholder. There is a spot in your Constitution that says this is where victims' rights is going to go. Because right now, if you read the language, and I encourage you to do that, and you compare it, there's no spelling out of rights. There's nothing that puts us on heightened alert as folks in the criminal justice system to say, I'm going to dot all my I's and cross all my T's because I want to be sure that I'm complying with everyone's constitutional rights. If it's there from the get-go, you know, there's no ambiguity. Nobody has to guess. Nobody has to go and look and see what the statute says. It's a right. It also means that the prosecutor and the victim, when they're at odds, and sometimes they are, the prosecutor's not the victim's attorney. you have some victims that might be asking for something that's not supported by law. In which case, the victim can raise their hand and say, Judge, I want this. And the prosecutor can say, the government doesn't agree with this, and this is why. And then the judge has to look that person in the eye and give them an explanation and be accountable as to why the situation is playing out the way it does. So it brings the victim from being a spectator to being a participant, to understanding why what's happening to them by this trial, to understand why it's happening and how it's happening.
Okay.
Any other questions by the committee? Senator Simmons?
Thank you, Mr. Chairman. Judge, I have just one or two questions before I get to your spectator versus participant characterization. In Arizona, you said that victims' rights, they've been in, I think
1989, 1990.
Okay, 1990, and it's in the Constitution?
Yes, sir.
And have you read the Victims' Bill of Rights in Mississippi?
I have read your statutes, and I have read your Constitution.
Okay.
And I do,
And,
yes.
and you would agree that victims' rights are in fact in our Constitution?
No, I would say that there is language that says they can be created by a body, the legislature.
So we don't have any mentioning of victim rights in our Constitution? Yes or no?
You have I can read it to you, sir.
No, I'm very familiar with it. I'm just trying to make sure you are clear about what you know about Mississippi, because I have to admit, I don't know Arizona like you. And so I'm trying to make sure you understand that in the Mississippi Constitution, we speak to victims' rights. Are you aware of that?
I am aware
Okay.
that you have a section in your Constitution, Article 3, Section 26A, that is called Victims' Rights. That's the title.
And the language that you have used in your presentation is the spelling out of victims' rights. The spelling out, that's what I've heard you say over and over again. It needs to be spelled out. And because I'm not familiar with Arizona, let me just ask you one or two questions about Arizona, because it may be different than Mississippi. The right to bear arms, is that a constitutional right in Arizona?
Yes, it is.
Because in Mississippi it is. But the Mississippi legislature, we've passed laws regarding church security teams. We've passed laws about whether or not guns should be at schools. And those two laws that we've passed as a legislature, it's actually not in the Constitution, it's in our statute, but we do have the right to bear arms in our Constitution. The right to vote, is that in the Constitution in Arizona?
It is.
Okay, good. How you certify elections? Who qualifies to run for office? Is that in your Constitution or is that in your statute?
I have to tell you that I am not familiar with election law.
Okay.
I wouldn't be able to answer that question, sir.
Well,
So
in the Mississippi Constitution, we have the right to vote. But the spelling out of all those rights to vote, how you elector participate in the process, how a candidate participates in the process, it's not in our Constitution. This same body has placed it, and in my opinion, rightfully so, in statute. Equal rights. Do you all speak to equal rights in your Constitution in Arizona?
we talk about no less vigorous than the rights of the defendant.
Okay.
No less vigorous, meaning that they have as much importance. They should be valued. Do they apply equally? There are cases where they don't, but they are listened to and they are valued.
Well, in Mississippi, we have language in our Constitution that talks about equal rights, but there are, countless statutes where we try to make sure that the rights of people are equally in Mississippi. My last example, which goes to, I guess, victims versus defendants, we, in our Constitution, Article 3, Section 26 of the Mississippi Constitution, are all the trial rights for a defendant. Are you familiar with that?
I do not have the trial rights for the defendant before me.
I mean, it just basically talks about the right to compulsory process, the right to subpoena people to court, the right to be presumed innocent, the right to an appeal. I mean, just the basic constitutional rights that are not only in the U.S. Constitution, but in really all of the 50 states' constitutions. Are you aware, Judge, of the criminal rules of procedure in Mississippi, where the Mississippi Supreme Court has actually outlined rules that we should go by in our criminal process, but those rules are not in our Constitution?
Of course not, sir. And I'm not, to answer your question, I'm not familiar with the criminal procedure rules in the state of Mississippi. But I
Okay.
can tell you that most criminal procedure rules are the same throughout our country, as should be victims' rights protections.
and I guess
they
my-
should be consistent throughout our country. The same way that I can know, and I walk into a Mississippi courtroom and I know that the defendant has due process rights and what those may be, the power to subpoena, the power to remain silent, the power to inadequate defense, whatever they may be, those are universal throughout our country. And the point I'm trying to make, sir, is that victims' rights should be universal too. They should have those same particular protections.
Okay. And all of our criminal statutes in Mississippi regarding crimes are codified in Title 97. Are you familiar with Title 97, the crimes title?
So, sir, if I was on the bench, I would say asked and answered, but because I'm not,
Okay.
I will tell you that I am not familiar with the code of Mississippi. I'm a practitioner or someone who has looked at the law in Arizona. If the point you're trying to make is that not everything is in the Constitution, I will concede that. We all know that. There's a hierarchy of rights. We know that there's local rules. We know that there's statutory rules. And we also know that defendants' rights have evolved over 200 years, and there are things that have been added consistently to what rights they already have to define what is already there. Victims don't have that. They don't have that beginning foundation. And what they need is that foundation so that you can build upon that and case law can interpret what's there. Very basic. The ability to have standing. If you are given a right and you don't have a remedy, it is not a right. That is Law School 101, Mayberry versus Madison. We all know that you have to be able to assert and enforce a right for it to be anything more than a nicety.
Now to your characterization that a victim should be more than a spectator and a victim should be a participant. And I just want to say I respectfully disagree. I've been practicing law in Mississippi for 15 years. I primarily practice criminal law, and I cannot name not one single case in 15 years that I've been a part of where the victim, as well as law enforcement, are not just spectators. They are in fact participants, because every district attorney, and it's just me, and you got other criminal defense lawyers that are on this committee, every single case that I've had, Judge, in Mississippi, the prosecutor values and listens to, as a participant, not a spectator, law enforcement as well as victims. In fact, in every case, and I can say every single case I've had in 15 years of practicing law, a plea offer or recommendation has not been made without the consideration of law enforcement and or the victim. And so the problem that you may be experiencing or you experienced before 1989 in Arizona, I can submit to you that it's not a problem in Mississippi. Our judges, our prosecutors, they are doing the right thing. And one question came up about accountability. The way in Mississippi, and I'm quite sure like in Arizona, we hold people accountable. An elected district attorney, an elected judge is at the ballot box. And every time, I always would like to raise that question. That's why I asked the sheriff when he spoke, who is your district attorney, who is your senior circuit court judge. Because if a victim, which would be my constituent, ever says to me, even on a case that I'm not participating on, that they are not being heard or not playing a part of the process, I take issue with that. I value victims' rights. I've been a victim of a crime myself. And throughout my own case, my DA, my law enforcement, they listened to me and they valued what I said. And in each one of our district attorney offices, we have 22 circuit court districts in the state of Mississippi. In each office, we fund a victim rights coordinator. And so if the issue is with the communication with the DA's office and or that coordinator, that's an easy fix. But our laws protect victims in Mississippi. Thank you so much for your time, Judge.
One comment, sir, and I was hoping not to have to talk about this, and I glanced over at Mr. Jones. He was not notified just recently that his case went all the way up to the Supreme Court. There was oral argument at the Supreme Court. He found out about it on the news. No one reached out to him from the state of Mississippi to get a position from him or to give him the opportunity to be heard. So while your experience has been wonderful, there are a lot of good prosecutors out there. I am telling you, they work hard at doing their job every day. There is no one who puts themselves into that calling, it's a calling, unless you really believe in what you're doing. But I can also tell you that there are some that don't follow it, that don't do it, for whatever reasons, I don't know, because they handle a million cases, you know, and there's a lot of them. So even though I respectfully disagree with you, and this is a civil discourse, and I am enjoying it, I can tell you that not everyone feels like you do, just like you don't feel like I do. It's not uniform throughout the state. There's not a consensus that this works. There's not a consensus, and that's what I'm bringing to your attention, and what I would like to see this body do is at least give it a fair shot. Let it be heard. Let it go to the Senate floor. Let the constituents talk to you. Let them reach out to you. Give it a shot. Let the people have take part in this process.
And just one follow-up based off what you just said.
I could speak
Yep.
for a long, long time, Senator.
Because you are a learned jurist, and I really respect everything you've said, Judge. But based off your last comment, whether something is in statute or constitution, wouldn't you agree with me that the application of it is always an issue? So right now, I mean, we can talk about all types of rights. I can't tell you unequivocally that the application of any other right, away from victims' right, whether it's in the Constitution or in statute that this body has adopted, if it's going to be applied the same way in Greenville, Mississippi, than it is in Grenada, Mississippi. I can't. So there's nothing about the proposal before us that would guarantee any application across the board. We just want to make sure we have the rights in place and that we have a framework to protect victims. And I submit to you, in Mississippi, we do.
Point well taken, but a constitutional provision will always trump a statutory provision. And I think you and I can agree on that. So
We're going to do one more question. Senator England?
Yeah, thank you, Judge. My question is actually for Ms. Hicks, if she wouldn't mind.
Sure, Ms. Hicks.
Ms. Hicks, thank you so much for sharing your story with us today. Do I understand that, if I remember the date you gave us correctly, the first assault that you suffered was in 2007?
Yes, they both were.
Okay, both were. Okay, and I'm just looking at Article 3, Section 26A of our Constitution, which is the victims' rights portion of our Constitution. That went into effect in November of 1998. So your assault happened after that, correct? Do you feel like your rights as a victim were protected?
Oh, no, definitely not.
Okay. Were you ever informed of victims' rights or certain rights that you would have had under the Constitution?
No.
Okay, so even though we had this in our Constitution in 1998, you weren't, you feel like you weren't protected under our current constitutional amendment as a victim in 2007.
I wasn't.
Okay. Thank you, Ms. Hicks. Thanks very much for being here today.
Thank y'all very much. Next, we're going to have Cliff Johnson, who's a director at MacArthur Justice Institute, University of Mississippi Law School, and he's going to join us via Zoom.
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. Can you see and hear me okay?
Yes, we can.
I do appreciate this opportunity to be heard today. I think it's important for us to recognize that all of us here are committed to the interests of victims. This is not a conversation in which anyone is here seeking to diminish or minimize the interests of victims or the importance of giving them a voice and a part in our criminal justice system. Certainly victims deserve to be treated with dignity and respect. And to Ms. Hicks, I would say, obviously I'm sorry about the events that occurred in your life and those of your family, and to the extent the system failed you. As a member of the bar and as a Mississippian, I'm certainly sad to hear that. And I know that those incidents do happen from time to time, and I want to talk about both the seriousness of that and the remedy that's appropriate in such a situation. I'm particularly sensitive because my wife of 30 years, when we first started dating, very soon after I got to know her aunt and uncle were brutally murdered, and I saw the effect that it had on my wife, on her parents, on her cousins. Those impacts don't go away, and they deal with them still today, so I'm particularly sensitive. I've practiced law in this state for 28 years. I've worked as a federal prosecutor, as a criminal defense lawyer, civil rights lawyer, and as a law professor. I know that this body is committed to victims' rights. The Mississippi legislature has shown a commitment to taking seriously the things that happen in people's lives, like the life of Ms. Hicks and Mr. Jones. And I appreciate the seriousness with which this body takes victims' rights. My experience as a practitioner here in Mississippi for all these years as a native of Mississippi, consistent with what Senator Simmons said, is that our judges in Mississippi do take very seriously the interests of victims. Our prosecutors in Mississippi do take very seriously the interests of victims. Law enforcement officers, like the Sheriff Patton, clearly take those interests seriously. I commend all of them for that, and I trust them to protect the rights of victims. My experience also is that there have been no efforts to eliminate, to reduce victims' rights in Mississippi. The Victims' Bill of Rights is firmly entrenched in our system of criminal justice. As someone who, from time to time, proposes criminal justice reform in the state, I have never, nor have my compatriots in the civil justice and civil rights world, sought to diminish those rights. And I know that if I were to bring such a suggestion to this body, you would laugh me through the roof of the rotunda. You would not have it, you would not accept it, nor would I expect you to. I contend that what we're talking about today, the proposition of putting Marcias Law on the ballot to amend our Constitution, is a flawed solution to a problem that just doesn't exist in the state of Mississippi. And with the permission of the committee, I'd like to share my screen. I have a PowerPoint I'd like to put up. Give me one moment. Are you able to see that, members of the committee?
Yes.
Yes, we can.
So my contention is that one size does not fit all and that Mississippi doesn't need Marcias Law. I appreciate the convictions of Judge Verdeen, and I was able to meet briefly Judge Cassell yesterday and understand his deeply felt convictions about the rights of victims, and I think we share much of the same feelings and attitudes about what the law owes victims. I know that our out-of-town guests have promoted this solution in states across the country. Some states have adopted it, many states have not. I will tell you that the situation in Mississippi, to my mind, does not warrant amendment of the Constitution, and I have serious concerns about the language that, in particular, of Marcias Law, and I want to talk about those concerns as we go forward. I first want to point out the existence of what I consider a robust protection of victims' interests in the state of Mississippi. My colleague and friend, Ms. Gillum, is going to talk to you in greater detail about why a constitutional solution is not appropriate here, why a constitutional response to any failures that occur in specific cases, such as the case of Ms. Hicks or Mr. Jones, those are failures that we should take very seriously, but why a constitutional response, and particularly I'm going to discuss why this constitutional response is not appropriate. I would note, in response to Judge Verdine's comment, that Section 26A includes less than 50 words about victims' rights, consistent with some of the comments made by Senator Simmons. I would note that the First Amendment of the United States Constitution, which guarantees the freedom of speech and religion and assembly and the press and the right to petition the government, is set out in 45 words. And it is not the number of words that determines the viability and how valuable a provision is. It is the fact that it states in clear terms, as does our Constitution, that we value the rights of victims. And it is important to note that it gives this body, the legislature, the authority to do the things that this body has done to preserve and protect those rights. So we have Mississippi Code 9936.5, which talks about the rights of victims and talks about the fact that they should be treated with fairness, dignity, and respect. We have provisions about protection from harm and being considered at the time bail is set early in the proceedings, the rights to be informed about relevant court proceedings. And then, of course, we have the Crime Victims' Bill of Rights, which is far more than 50 words. It occupies sections 9943.1 through 9943.49 of our code. And I would encourage you, I believe that you have the handout that I provided to the staff. Do you have before you Attorney General Fitch's victims brochure? Is that available to you?
Yes, we have it.
So as you can see, from the Attorney General's office on down, the desire to inform victims of rights, to provide a vehicle to opt in, as Judge Verdine referenced, to advise regarding compensation funds and the role that victims play in our system under the current regime are extensive. I encourage you to, if you have not, study that Victims' Bill of Rights or that summary that appears in Attorney General Fitch's brochure, and to consider the extent to which the protections that are discussed, many of them that are discussed in Marcias Law, are addressed and have been addressed by this body through the Crime Victims' Bill of Rights. I want to talk about specific concerns that I think we need to be thinking about in Mississippi, and I'm going to go fast because I am aware of our time limit. I was told I had 10 minutes, and so I'm going to do the best I can. You know it's hard for lawyers. It is important to note that Marcias Law expands the reach of these rights into the world of misdemeanors. And it says beyond felonies, which has been our focus heretofore, that this also includes all misdemeanors involving physical injury or threat of injury, which would be all misdemeanor assaults, all misdemeanor batteries, and our part-time judges in our part-time courts with our part-time prosecutors and our overwhelmed clerks are going to feel the impact of this. I think it's important to talk to those people about the implications of that expansion. This provision also speaks specifically about delinquency actions. And if you talk to juvenile justice experts and advocates about the civil actions that take place in the delinquency context, not criminal proceedings, actions that take place not in public in the juvenile justice system, they will tell you that there is specific complexity around delinquency actions. The role of victim and offender often is fluid and unclear, and experts have expressed to me concern about the notion of treating children in a manner that is designed to be applied to criminal cases, and assure me that the youth court system, and any of you who are involved will know this, that the youth court system in Mississippi does take very seriously the rights of victims. We know that this is not the first time Marcias Law has been proposed in Mississippi. And for those of you who have been around in previous efforts, you know that domestic violence advocates have expressed concerns about the adoption of Marcias Law. And it's similar to the delinquency context in the domestic violence world. The identity of offenders and victims is fluid. And the person who is the victim today may be the offender tomorrow, or vice versa. And the notion that the first person who gets to the prosecutor can claim victim status and have constitutional protections equal to those of the defendant is the source of concern. And I encourage you also to talk to domestic violence advocates in Mississippi regarding concerns that, if they have not expressed them this go-round, certainly have been expressed in the past. I think it's very important to focus on the reality that this language says specifically that the victim shall be protected in a manner no less rigorous than the rights afforded to the accused. Now, this is going to create significant challenges for judges and prosecutors. Judges and prosecutors who already take the rights and the interests of victims very seriously. There are going to be situations, and I'll talk about some examples of that, where now judges and prosecutors who are told that the rights of victims in the criminal system should be protected in the same manner as the rights of the accused are going to have very difficult decisions to make, and this constitutional language provides no clarity about what to happen in the event of a tie. What the implications are for this new status for victims. I think it's important to recognize, too, to say that the interests of victims are different than the interests of accused people whose liberty is at stake. To say that those aren't the same, don't have the same force and import in the criminal proceeding is not to diminish our interest in victims, or is not an attempt in any way to exclude them from the process. But take, for example, the fact that this language provides the right for victims to proceedings free from unreasonable delay, basically a victim speedy trial right. And now the defense counsel says, I need a continuance because I need more time to review discovery. We're not ready to go to trial. And the victim says, oh, heck no. I want my day in court. I have a constitutional right to a speedy trial. Prosecutor who might otherwise have agreed to give additional time, I want you to push forward. Judge who now has confronting him conflicting positions that are to be recognized equally, is in a situation where due process concerns are very real. There are rights, as Judge Burdine mentioned briefly, to refuse depositions or other discovery. I would point out that Rule 17.5 of the Mississippi Rules of Criminal Procedure, adopted unanimously by our Mississippi Supreme Court, provides the right to depositions in those cases where the court deems it appropriate. Victims have the right to refuse informal depositions now. Victims regularly exercise that right. I can assure you that because as a criminal defense attorney, I have on many instances requested interviews and have been denied by the victim or their lawyers those interviews. Rule 17.5 allows for depositions, and this constitutional amendment says that cannot happen. There are confrontation clause concerns here, and the rights of defendants to prepare for trial are important. Burdens on prosecutors are significant. Members of the committee, I encourage you to speak privately with your local prosecutors and district attorneys regarding their feelings. One, about the extent to which they already enforce and protect the rights of victims, and two, about their concerns regarding Marcias Law. This law expressly states that the victim can request that the prosecutor assert the rights of the victim that are laid out in this proposed amendment, and any other right of the victim afforded under any law. So this creates a very difficult situation for prosecutors. You're the attorney for the state, and now you've been asked to represent the interests of the victim. And anyone who's been a prosecutor knows that that's not always easy, and those interests aren't always the same. We don't know from the language of this amendment what the implications are of a prosecutor who says no. It also says that prosecutors must reasonably confer whenever the victim requests it. What does that mean? What is it to reasonably confer? What happens in cases that are not so uncommon where there are multiple defendants? A credit card fraud case where there are 125 people whose credit cards have been used. Whose rights are sacrificed? Don't all 125 of those people have rights under Marcias Law? It's certainly the way that the amendment reads. And what are the implications of denying those people their rights due to the reality that the court can't handle the participation of 125 different people? The express language of the amendment doesn't provide for that. There also provides a burden on courts. Courts are now going to deal with this new equal standing between victims and the accused. Judges who already take these actions very seriously, who ask prosecutors, have you conferred with the victim? Have you talked to them about what's going on? Or find themselves with a different balancing act and a difficult effort to weigh and implement these equal rights. This language requires the court to act promptly on all requests for rights by victims. It says that they shall act promptly. Promptly, of course, is not defined. And what are the implications of failures to do so? When you start talking about the consequences of failure to comply, I think it's important to note, one, no cause of action is created by this. So the notion that this somehow is going to make everyone instantly comply with the requirements set forth in this language, I think gives this language far too much credit. It does say that there's no right to damages or compensation, but it doesn't speak to what's going to happen as far as injunction or a declaratory judgment or writ of mandamus against judges who victims think are not adequately protecting their rights. Finally, do all victims get equal rights? If a rich businessman from Madison can hire 4 lawyers from Butler Snow to defend his rights when he believes he's a victim of a crime, and a poor victim from Macomb or the Kill or Greenville has no capacity to hire a lawyer and to invoke and avail himself of those rights, are we going to accept that arrangement? The response I would expect is, well, if you can't afford it, you can ask the prosecutor, which throws us into the problem that I identified earlier. The Sixth Amendment doesn't say that in the context of public defenders that the state has to pay for lawyers, but in Gideon, to the surprise of a lot of states, the Supreme Court said, yeah, the state has to pay. I can tell you that civil rights lawyers like myself are going to be very interested in the notion of this body creating, or the state adopting a constitutional provision that creates rights that can only be accessed by people with money, and that people who don't have money can't benefit from. I'm concerned about that. One size doesn't fit all. This is not the answer for Mississippi. I do encourage you to speak to prosecutors and judges and youth court staff and to domestic violence advocates. And I encourage you to speak to people who've been involved in the system as lawyers. This body has shown an unwavering commitment to the interests of victims. That's not going to change. Don't give up your flexibility to amend existing laws, to pass new laws pursuant to the direction of Article 26A as the need arises, as circumstances change. You have that flexibility now, and you've shown the capacity to act responsibly. The interests of victims are taken seriously now. They're going to be taken seriously in the future. The notion that if we don't have a constitutional amendment, that victims won't be cared for and won't be heard is simply not the case. As Mississippians, we know that's not the reality here. We know that it's just not true. I care deeply about what happened to Ms. Hicks and Mr. Jones and all other victims of crimes, and I am saddened to the extent that the system hasn't always worked. The answer isn't a constitutional amendment. The answer is work on implementation of the rules we already have. This amendment doesn't automatically make things perfect. And as I've expressed, I think it creates a plethora of concerns, legitimate legal concerns, should the state adopt this amendment. And I encourage you as a committee not to bring this action forward. Thank you for allowing me to be heard.
Thank you very much. Does the committee have any questions for Mr. Johnson? Thank you very much.
Thank you.
Next, we'll have Vicki Gillum with the Gillum firm.
Thank you. Chairman Johnson and other Senate committee members, thank you for the opportunity to provide testimony today regarding House Concurrent Resolution Number 35, commonly referred to as Marcias Law, relating to constitutional rights of victims of crime. My purpose here today is to provide testimony to support you to vote in favor of continuing to allow this legislature to enact the law regarding the rights of victims in criminal proceedings, as it has always done, and to vote no to placing this resolution before the entire Senate. I would urge the members of this committee to vote against the placement of this resolution as a proposal to the electors for an amendment of our state constitution of 1890. This resolution that's before you grabbed my attention because it is an amendment to our Constitution. I am a true believer in the governments created by our constitutions, and especially in protecting the rights created in our constitutions. My life's work has been to use my skills and talents in ways to protect all constitutional rights afforded to individuals, especially those rights related to the criminal justice system and the jury trial system. I've been practicing law for almost 28 years, and I've always been passionate about respecting and protecting constitutional rights. In those years, I have done this by both prosecuting at all trial levels in our courts, by defending the indigent accused at hearings, trials, and by writing criminal appeals. I've also represented victims of crime in civil courts. I've trained law enforcement, and I've taught the theory and concepts of constitutional procedural law as a full-time professor for 4 years of criminal justice at Mississippi College. And so my interest was also that this proposed amendment to our Mississippi Constitution was related to our criminal justice system. My first reaction after I looked at this proposal was, this is not written as the type of language that goes into a constitution. Once I absorbed the content of the proposal, my first thought was, wait, we don't even need this, because we have victims' rights protected in our Constitution, and we have worked extremely hard to include those rights and protect them in our criminal justice system in Mississippi. We have a great law that is working. So my next thought was that I somehow needed to speak with you about my strong feelings about this proposed amendment. At that time, I didn't know how or where this proposal came from. In fact, I couldn't imagine anyone in this state feeling the need for change to our existing law. After researching, I found that this content came from outside of our state and is being funded by a man from California and pushed for inclusion in every single state's constitution. I was relieved. I practiced law for over 5 years directly in the criminal courts of Hinds County, Mississippi, as a very young public defender. I'm getting old now, and I can say this. I remember when victims' rights laws passed. I remember what it was like before. I was already teaching criminal justice at Mississippi College when the law passed. I was proud to include the entire sections in my classes about the newly passed victims' rights laws. And as I returned to the courtroom in the criminal courtrooms of Mississippi and actively began to practice in the system on both sides, I really saw the difference Before our law, we rarely saw a victim at court, but after that, they were at all our hearings and proceedings. Go to court, observe. Victims are there. They are participating, and it is a good thing to see. They have rights. I have seen the rights not only be adhered to and respected by the component parts as well as those who work within the system. Prosecutors, judges, defense attorneys, defendants, law enforcement agencies, and correction officers. And so allow me to turn quickly to why I felt the need to speak with you, and indulge me please to share my love and passion for constitutional history, especially the importance placed on individual rights in our federal and state constitutions. To begin with, our U.S. Constitution is considered to have created the greatest of all governmental structures in the history of the world. I believe that, at least thus far, since its ratification. However, the body of the Constitution upon completion went to the states with no concepts of preservation and reservation for certain rights. Imagine that, a Constitution that now didn't preserve individual rights. That's how it started. After the document was sent to a few states, some of the initial framers who wrote that Constitution began concerned. We created a strong central government. It could become too strong. They had just fought to rid themselves of a government run by a king that had taken advantage of the colonists in America. You all know this story. That's why it was so familiar to them, and they were concerned. And they began to write. James Madison leading them, and others wrote the Federalist Papers. And slowly, voters began to read about their concerns. So in order to actually complete their original ratification of the Constitution, it had to be amended. The first 10 of those amendments, the Bill of Rights, listed the general rights of individuals, which should be protected from the strong government, which they had created. Those rights were written in short, succinct statements, all the better for judges and justices to interpret as certain facts presented themselves to the courts. It took 100 years before those rights became applicable through the 14th Amendment to the states. And around the same time, our current Mississippi Constitution was written. Our living Constitution, like the U.S. Constitution, specifically protected and protects certain individual rights from which our citizens would need to be protected by the power and strength of a Constitution. Among them, we find speech. Senator Simmons said it well. It's just freedom of speech, freedom of religion, freedom of assembly, the right to bear arms, the right against illegal search and seizure of our property or persons, the right to a public trial, the right for the defendant in criminal proceedings to have counsel, and the right to have due process. That is a notice, a hearing, and an appeal before certain rights can be taken away from you. So, the rights we feared could be infringed upon by the government the most were those that were placed with superior importance, as should be our first concern. Courts have recognized that constitutions, especially the Mississippi Constitution, have been written in such a way to stand for a long time. I agree very much with that. We find both courts and scholars saying that a good constitution is presumed capable of ordering human affairs decades after its making, under circumstances beyond the prescience of the draftsman. It is not a temporary document. It was designed to be incapable of expansion or development or movement with the living current of the times. In fact, violations of constitutional rights are reviewed by the courts and are given strict scrutiny if the government violates those rights. Between Section 5 and Section 32 of Article 3 of the Mississippi Constitution are our Bill of Rights. As one of our most noted Mississippi scholars of Mississippi jurisprudence, former Justice Jimmy Robertson, wrote in his treatise, which I encourage you to read, on the Mississippi Constitution, he said these rights, they are, without exception, expressed in grand general language. Each has its core of certainty, and its penumbra of doubts. In most cases, the implementing of details of those rights are provided by the legislature. Quote Justice Robertson. Justice Robertson also wrote that two core values underlie the structure of government provided in the Mississippi Constitution in general and in our Bill of Rights in particular. These are, first, the inherent dignity and worth of every individual, and second, the individual's entitlement to fair play in all of his or her interactions with the government. These values have found expression in our current Victims' Rights Amendments in our Constitution, which is now a part of our Bill of Rights. We have it. This is what it says. Victims of crime, as defined by law, shall have the right to be treated with fairness, dignity, and respect throughout the criminal justice process, and to be informed, to be present, and to be heard when authorized by law during public hearings. And yes, the Constitution gave you the power to change what these definitions mean, what the law is, and to consider it every single year. And you have. In 1998, victims' rights were placed into our Constitution in a perfect way. They were strong enough to give protection, but left enough room for the legislature to specifically have the power to create the necessary law. In 1998, as I stated, I witnessed that power as this legislature passed an entire chapter of law that declares and expands on the constitutional rights. I watched as our criminal justice system adapted, and victims were embraced, and the rights of those victims were respected by our entire criminal justice system. While criminal law, what is or is not a crime, can change, and we've seen that recently, very much so. You see it every year. Constitutional rights of victims cannot be eroded. Listen to that. It's in the Constitution. They cannot be eroded past what's there. And under our current constitutional law, the legislature has more power to change, strengthen, enforce, or create more victims' rights if there's ever any need. The legislature has continued to pass laws that provide compensation and aid for victims. Each and every session, I am sure that you consider laws regarding victims. This is because the beauty of the current language and our Constitution has bestowed that power upon you. And I want to reassure you that we already have an ever-present, passionate, and earnest recognition of victims in our criminal justice system every single day. I'm in the courts. I'm there on both sides. I see it. I know it to be true. I know that everyone in those courts talk to the victims, they work with the victims, they respect, as our Constitution says, the dignity of those victims. My plea to you is to allow our current constitutional provision to stand. It is not only sufficient, but it's proven to have created the task for which it was intended, to identify the core rights of victims and to empower this legislature to act in ways that have secured those rights. To put more detailed language and specificity into the Constitution, as in Marcias Law, destroys this proven accomplishment. A reminder as you vote that constitutional rights are expressed in grand general language with a core of certainty and a penumbra of doubt. And the body empowered to define those rights with more specificity needs to remain with the legislature. With all good intent, if this proposal leaves this committee and goes to the floor, it will be passed. At that point, a vote against it would be seen as a vote against victims' rights. If it's put on the ballot for the voters, it will be passed. The voters in this state either have been victims of crime, I have, or they certainly know someone who has. Our citizens empathize and they sympathize with victimization. Emotion will pass this Constitution Amendment. However, this committee, you, each and every one of you, are charged and elected to make wise decisions for Mississippians. If this proposal is passed from this committee, the resulting amendment to our Constitution will not benefit our victims by allowing the fluidity of changes necessary to properly maintain those rights for generations to come. I ask you to vote no to this proposal and allow our current constitutional language to stand as written. This legislature has done its job. It's done a great job as empowered by the constitutional language by creating good law that has incorporated victims solidly into our criminal justice system. Thank you.
Thank you, Ms. Gillum. Is there any questions for her? All right, thank you very much.
Thank you.
Next, we'll have Judge Paul Cassell, who will be joining us via Zoom.
Thank you, Chairman Johnson, Vice Chair Simmons, other senators. I appreciate you giving me the chance to provide some testimony by Zoom. Just a quick bit of background about me. I'm an unpaid policy advisor to Marcias Law. I was a federal judge here in Utah from 2002 to 2007, and I resigned my position to go back to teaching law here at the University of Utah College of Law and to work on behalf of crime victims' rights. I think one thing the committee should understand is that the victims' rights law is a specialized body of law. It's not something that people can just jump into instantly and pick up. And it's a subject that I teach every year at the College of Law. I have a case book here that I use to go over the material. And I do a lot of work around the country arguing for crime victims. This morning I was in the 11th Circuit en banc, the U.S. Court of Appeals there, via Zoom, arguing for Jeffrey Epstein's victims, the victims of the sex trafficking organization, trying to enforce their rights. So against that backdrop, I think it's important to look at some of the arguments you've heard against this provision, this proposal, and understand that the sky will not fall if it is enacted. You can look at the experience of other states and look at how the law would operate and reach that conclusion for yourself. Senator Thompson, I think earlier today, asked a very good question, which is, look, how does this work in practice? What would happen if it were put into place? And I think what you would see is victims would become more actively involved in the criminal justice process. They would not have the kind of experiences that, for example, Ms. Hicks described as her experience under existing law. Prosecutors would get a file, they would make the decision to charge. Nothing in Marcias Law takes away any prosecutorial discretion in terms of charging. But I do think you would see things happen differently as the case moved forward. For example, Ms. Hicks talked about not being notified about a bail hearing, and a judge letting someone go that sounds to me, I suspect sounds to like everyone there, someone who should not have been released. One of the things Marcias Law does is make sure that victims are in a position to provide information, not just to prosecutors, but also to judges. And I suspect that if Marcias Law had been in effect back when the crimes were committed against her, she would have been able to go to that judge and say, look, judge, here's what happened to me. Here's the damage that was inflicted on me. Here's the threat that he poses to my family. I urge you not to grant bail to him, not to release him. And victims aren't demanding that they control the decision. They don't want a veto over the process or a veto over the judge's decision. They simply want to have a voice in the process. And that's what this proposal would do. Now, we've heard today that there's some notion that this is a one-size-fits-all solution, just a cookie-cutter proposal that would be put into Mississippi law and indeed into Mississippi's Constitution. That's not the case at all. I'm familiar generally with the negotiations that have gone along. I've seen a lot of language that's been added into this proposal. And let me just talk about some of the unique Mississippi features that have been added into this proposal. A lot of other states have a very sweeping definition of crime victims that include, for example, victims of petty theft. Working with the Mississippi prosecutors, the drafters of this proposal, have narrowed it down, and so it's very focused in on the cases where there are the most serious victim concerns, felony cases and misdemeanor cases involving physical injury or threat of physical injury, sexual offenses, or spousal domestic violence. It does expand the reach of your victims' rights enactments. I think Professor Johnson mentioned that. I see that as a good thing. It's important that victims, for example, of domestic violence offenses, have something in the Constitution that protects their rights. And that's what this proposal would do. Also, this expands the operation of victims' rights laws in juvenile proceedings. And again, I think that's not a problem, but a feature of this enactment. It would ensure that if someone is, let's say, raped or even killed by someone who happens to be 17 years old or younger, that they're going to be tried in the juvenile justice system. Victims will be able to participate and attend those hearings and see that justice is being done. In addition, there are several provisions here. We heard some suggestion that this provision might somehow take away rights from criminal defendants. That's not the case. That hasn't been the case in other states, and certainly wouldn't be the case here. There's a specific provision that says that this section, being capable of protection without denying the constitutional rights of the accused, is not intended and may not be interpreted to supersede a defendant's federal constitutional rights. In addition, there's another provision that was added in, again, working very closely with stakeholders in Mississippi to make sure the language was appropriately crafted. It says nothing in this section shall afford the party victim party status or be construed as altering the presumption of innocence in the criminal justice system. And those are provisions that are not found in many other state constitutional provisions. And again, I think shows and makes the point that this is a specific proposal that addresses specific needs in Mississippi. And that's probably the reason that I believe more than 100 members of the Mississippi House of Representatives have voted in favor of the proposal. I think it's rare nowadays in a country that seems to be split along partisan and other lines to see a proposal getting 100 votes. This one, as I understand it, has received that many votes in the House, and I'm assuming would command, hopefully should command widespread assent in your Senate. Now let's talk about a couple of the details, because Professor Johnson had some questions about how some of the provisions would work. He noted, for example, that this proposal would give to victims the right to refuse a deposition. And he said this could have confrontation clause implications, I believe was the word that he used. It actually will not interfere in any way with the defendant's confrontation clause rights. Defendants have a right to confront witnesses during the trial. Nothing in this proposal changes that whatsoever. He also mentioned Rule 17.5 of the Mississippi Rules of Criminal Procedure and said that that would somehow be interfered with by operation of Marcias Law. Rule 17.5 is a evidence preserving provision. It allows a deposition to be taken for the purpose of preserving testimony. For example, suppose a victim has cancer and is going to pass away in a month. That victim's testimony can be preserved. That is different than the kind of depositions that Marcias Law would address. Marcias Law says you can't depose somebody simply for purposes of obtaining discovery. And that's quite consistent with existing Mississippi law. If you look at Each versus State, 665 Southern 2nd 852, a 1995 decision, you see that Mississippi law indicates that courts cannot compel victims to be forced to testify pre-trial. The Marcias Law provision would enshrine that in the Constitution. What about proceedings from unreasonable delay? Professor Johnson gave a hypothetical scenario. Suppose the defendant isn't ready for trial and the victim says, we want to go to trial right away. Well, that's what judges are there for then, to evaluate those competing concerns. And if the defendant truly isn't prepared for trial, of course the judge is going to grant the continuance. But what this does is at least give a victim the opportunity to put the issue in front of the judge to see whether there's a good reason for delay. And this is language that already exists in many states. I was a federal judge for 5 years. From 2004 to 2007, we had the same right in the federal system, and it didn't create the kinds of difficulties that some have ascribed to a speedy trial right. And again, it's interesting. I know that your Mississippi Constitution already has a provision giving rights to defendants. That's, I believe, Article 3, Section 26, if I remember the number off the top of my head. And why shouldn't victims have a parallel right to criminal defendants? In fact, it's interesting when I talk to victims around the country, they say, look, Professor Cassell, we're not asking for special treatment. In fact, we just want to be treated like criminals. If I was a murderer and I went to court, I would have the right to speedy trial. But what if a member of my family was murdered? Shouldn't I have the same kind of right to have the case handled without unreasonable delay? Now let's turn to one of the most important points of the new proposal, and that's enforcement. And I think that's one of the areas where you really see something lacking in your existing law. I'm familiar with the state constitutional amendments protecting crime victims' rights around the country, and frankly, I'd say Mississippi is one of the 2 or 3 weakest that I have seen. If you want to find stronger versions of victims' rights constitutional amendments, I would direct you to Florida, or Georgia, or North Carolina, or Oklahoma, all states that are within short driving distance of your state, and all of which have taken an initial version of crime victims protections and brought it into the 21st century by upgrading it and improving it. I think the number of words that your current provision has, while not determinative of whether it's a strong or weak provision, certainly illustrates the problem. You have 40 or 50 words dealing with the subject, whereas the other states have added a number of words to their state constitutions to make sure that victims are treated appropriately. One of the key issues is enforcement, and I thought Sheriff Patton, who's on the ground there in Mississippi, described it quite well, and he said, look, currently we really don't have teeth in the notification requirements that exist, and this proposal would make these rights enforceable. They would make sure that courts and prosecutors and judges all would be ensuring that victims' rights are respected throughout the process. We've heard some suggestion about funding implications. I think the experience in other states here can serve as a useful guide. There are not significant funding implications to giving victims rights. The only real funding that's required is to provide, I guess back in the day it would be postage stamps to send out notifications. Nowadays, of course, with email, even that modest cost is reduced. And my understanding is that Mississippi already has victim witness coordinators that could handle many of these things. So you're not going to see some kind of unfunded mandate or significant funding issue associated with this. There was some question about, well, how would this work for equal rights? I'll bet a rich person could take advantage of these laws in ways that others could not. I was frankly fairly surprised to hear that argument being made, because that's usually an argument for advancing these kinds of state constitutional amendments. Right now, it's someone who really requires a specialized lawyer to burrow down in from the state constitutional amendment, and then you go into the statute, and then you go to the provisions of the rules of criminal procedure. Ordinary citizens are not able to engage in that kind of legal research to understand what their rights are. Someone who's wealthy can perhaps hire an attorney to do that. What Marcias Law would do would elevate those rights up into your state constitution, where they're more accessible to rich and poor victims alike. And let me close with this. I know one question that's been asked several times is, well, why does this have to be in the Constitution? I'll bet the legislature could take care of all this. Well, here I think it is fair to look at the experience, not only in your state, but in other states. And the experience around the country has been uniform. State statutes are simply not strong enough to get the job done. That's the conclusion, for example, the United States Department of Justice, which in fact has called for a federal constitutional amendment to protect victims' rights. This would be, I think, a more modest step, an improved state constitutional amendment. And you already have, as Judge Verdon pointed out, I think what really is accurately described as a placeholder. There really are not substantive rights spelled out in that provision. You have to hire a lawyer and drill into some of these other bodies of law to figure out what's going on. And so here, I guess I just disagree with what I heard from Ms. Gilliam a few moments ago. She says we have put into the Mississippi Constitution victims' rights in, quote, a perfect way, close quote. I really don't think that's the case, and it was hard for me to understand Ms. Gilliam's argument, having just heard from Ms. Hicks describe her experience in your state and the way that she was treated in the criminal justice process. I think Professor Johnson was more candid when he described the way things happen in Mississippi right now, which is my experience in other states. He said, quote, incidents like this, I guess the incident that happened to Ms. Hicks, happen from time to time. And I think that's probably an accurate statement. And so the question that this committee needs to decide is, those incidents are terrible. Those incidents are literally life-threatening. Those incidents demand the best possible response from the state of Mississippi. And what is the best possible response? Putting it into your fundamental charter that people like Ms. Hicks and countless others will have a constitutional right to be notified about court hearings, to tell the judge before someone is released on bail that this man is a danger and look what he might do, to be heard before a plea bargain is entered into, so that if there's something that's inappropriate, the judge can take that into account. And then to give victim impact statements about the need for restitution, and to be informed about restitution, as Ms. Hicks was not under your current law. And here's one point, I'll just close with this. I tend to agree with Ms. Gillum. I'm not a student of Mississippi politics or your state citizenry the way she is. But she says, look, if this proposal goes to the Senate floor, it will pass. And if the Senate passes this proposal and sends it to the voters, it will pass. My understanding is that's absolutely right. And my understanding is that that's absolutely a reason why you should send this to the floor and you should send it to your state voters. Mississippi exemplifies its values through its state's constitution. And the question that you have to decide is, do you want to have one of the weakest state constitutional protections for crime victims' rights in the country? Or do you want to have a protection that will serve as a model for other states, and will serve to protect your victims whenever they are unfortunately thrust into the criminal justice system? I think that's the proper way to look at the question, and the proper answer to that question is you should send it to the floor, and then you should send it to your voters. And I'd be happy to answer any questions that you have.
Any questions from the committee? I just have a couple of quick questions. It seems to me that there's three parts to this. The appropriate place for the details and definitions, is it in the Constitution or should it be in statute? Should the current statute be changed or improved? And can or should the application of the statute be improved? Would you agree with that?
I think that does cover the waterfront of issues, yes.
Okay. And specifically here today, what we're discussing is the appropriate place for the details and definitions.
Well, I wouldn't describe them as details. I think, for example, when you look at Ms. Hicks' case, the right for her to speak to the judge and say, don't let this man out on bail is not a detail. That is a fundamental right. In fact, I think it's not an exaggeration to say that it's a life or death right. Fortunately for her, she survived. But there could be other situations where victims are not heard. Man gets out on bail and sadly carries out a homicide. So these are not details. These are fundamental rights. These are what I would submit should be the fundamental values of the citizens of the state of Mississippi. And those fundamental values belong in your state constitution.
But regardless, and let me make sure I understood you correctly, you said letting him out on bail, is that what you said?
Correct. Ms. Hicks's assailant was released on bail, apparently without the judge getting full information about the danger that he posed to her.
But even if he did, it would still be at his discretion regardless of if this was in the Constitution or in statute.
That's right. Ms. Hicks did not have a veto over the process, but she would have a voice in the process. And that's what this amendment is all about.
But we could also give her a voice in the process through statute.
Well, you've tried to do that. You've tried to do that, I guess, now for 25 years or more. And what we're hearing from people on the ground in Mississippi is that that hasn't worked. And that's what we hear as victims' rights advocates all over the country. I think one way to look at the issue is this way. Suppose the defendant said, look, I'm not getting my rights. Would you say, well, don't worry, we can tinker with the statutes and fix it? No, you put defendants' rights in your state constitution because those are fundamental values. You want a defendant to have a right to a jury trial and a right to counsel. So I think ultimately you have to decide, is it a fundamental right for people like Ms. Hicks to be able to address the judge and say, don't let this man out, he may kill me. I think that's a fundamental right that should be in your state constitution.
And if it were in the Constitution, do you believe it would prevent any instances like that from happening again?
I think it would significantly reduce the likelihood of an incident like that happening again. I have to say I don't like the term incident to be used to describe attacking someone with a knife and inflicting more than 30 wounds. I think it would prevent crimes like that and even potential homicides that were at risk there.
Would it prevent a judge from not hearing from a victim?
It would certainly be. I mean, let's be clear. I'm not saying that this is going to be perfect. I am saying this is going to be better, and that's the experience around the country. When you elevate these rights to the Constitution, you find that judges pay more attention to them, prosecutors pay more attention to them, law enforcement pays more attention to them, and that's just human nature. When you increase the level at which something is spoken of, when you put it into the supreme body of law in the state of Mississippi, it wouldn't be surprising to see people paying more attention to it.
All right, thank you very much. Our last presenter is going to be Kyle Williams. He's with the Attorney General's office.
Chairman Johnson, members of the committee, I want to thank you for having a hearing on victims' rights. It's a critically important topic, but secondarily, on behalf of the Attorney General, for inviting us to participate in this process. We do appreciate it. I've provided all of you with some literature that is created and disseminated by the Bureau of Victims Assistance in our office. And so just a little background, the Bureau of Victims Assistance is a standalone division in our office comprised of attorneys, advocates, and support staff. Their sole duty is to serve victims all across the state. They serve as a resource. They connect victims to service providers, different resources, funding mechanisms, and different things. And so you'll see in that documentation that I've provided that Bureau really covers the gamut of services to victims. And so you'll see in there that there's information related to the Crime Victims Bill of Rights, which we've heard a lot about today. But also there's information about the referrals to victim service providers, detailed information related to the judicial process, kind of what victims can expect as the offenders travel through the criminal justice system. And then there's also information on how to submit a claim to the Victims Compensation Trust Fund, which provides funding to reimburse expenses incurred in relation to the crime. And so just by way of example, that our Bureau of Victims Assistance gave out over $2.5 million last year under that fund. And so that's a really busy division in our office. I've included the contact information of the director of that division, Terry Gleason, who's a great resource. So if you need any additional information about what that division does and kind of the details of that, I urge you to reach out to her. And so I won't dwell on that, but I wanted to let you know that in addition to all of the interaction with victims being had across the state by DA's offices, local prosecutors, and the like, our office does that daily and has a standalone division to be able to handle that. So since the committee is considering advancing a constitutional amendment that would bear on victims' rights, I think it's important to kind of have some understanding, at least generally, what the current lay of the land is. And I think that the speakers today have spoken about it a lot. And so we've heard about the constitutional provisions and the Crime Victims Bill of Rights. And so I'm going to kind of walk through that again. Some of it might be redundant, and I guess that's one of the risks of going last. But I was glad to go after the federal judge, though, certainly. So by way of background, we've heard it already today. 1998, the legislature passed, and ultimately the voters approved a constitutional provision that granted crime victims, quote, the right to be treated with fairness, dignity, and respect throughout the criminal justice process, and to be informed, to be present, and to be heard when authorized by law during public hearings. And that constitutional provision also authorized the legislature to, quote, enact substantive and procedural law to define, implement, preserve, and protect the rights guaranteed to victims by this section. So the current language within the Constitution sets forth those broad rights and says, legislature, you go forward and you fine-tune this and you kind of prescribe specifically how all this should be done. And so, as we've already heard today, in turn, the legislature did just that. In 1998, they passed the Crime Victims Bill of Rights, went into effect after the voters approved the constitutional amendment, went into effect the next year. And so, in passing that law, the legislature said that its purpose was to, quote, ensure the fair and compassionate treatment of victims of crime, to increase the effectiveness of the criminal justice system by affording rights and considerations to the victims of crime, to preserve and protect victims' rights to justice and fairness in the criminal justice system. And I'm not a prosecutor. I've spoken with several prosecutors who are quite proud of this statute, and apparently it's viewed pretty widely as being a really good source nationally for victims' rights. The constitutional provision coupled with the Crime Victims Bill of Rights. And so in trying to kind of understand the impact of the constitutional provision and the statute, just last year, the Mississippi Supreme Court had the occasion to talk about the Crime Victims Bill of Rights. And they said that by the legislature enacting that act, that, quote, victims of crime were formally recognized and afforded substantial rights, including the right to be provided information by law enforcement, the right to confer with the prosecuting attorney, the right to receive a transcript of the proceedings, the right to be present throughout all proceedings, the right to participate during any entry of a plea of guilty, sentencing, or restitution proceeding. The Mississippi Supreme Court went on to say, again, in describing the two-step process, the constitutional amendment and the statutory enactment, not changes, enactment, the court said that changed the landscape in Mississippi to, quote, protect victims from being traumatized again. And so that's the Mississippi Supreme Court just last year. So we've seen, Mr. Johnson has also disseminated a copy of this piece of information. I included one in that red folder that I handed out. And you can see that the Crime Victims Bill of Rights there's a lot there. So I'm not going to endeavor to cover all of that today. I'm going to try to hit the high points. And again, we've heard about some already today, so you'll have to forgive me for being redundant. So first, within 72 hours of a law enforcement agency becoming responsible for investigating a crime, the victim has a right to the following information. And the statute is worded, law enforcement shall provide the following information. And this is not all of it. This is just, again, some of the high points. That emergency and crisis services and victims' compensation benefits and restitution, as applicable, are available. The name of the law enforcement officer and the telephone number of the law enforcement agency and prosecutor's office involved, the procedural steps involved in a criminal prosecution, to be notified of the rights afforded by the Mississippi Constitution, and to be provided a form for invoking those rights. And you'll see this all in that pamphlet. And then a recommended procedure if the victim is being subjected to threats of intimidation. And so continuing to walk through these rights, a victim has the right to receive a copy, upon request, a copy of the initial incident report of the case and notice of all charges filed against the defendant and any criminal proceedings other than initial appearances. A victim has the right to receive adequate protection from harm and threats of harm arising from cooperation with prosecution efforts, and the right to have a judge take the safety of the victim or his or her family into consideration when setting bail for the accused. And so I think that provision is not from the Crime Victims Bill of Rights, but is from a section immediately preceding that. A victim has a right to confer with the prosecuting attorney prior to the final disposition of a criminal offense, whether it be before trial or about a decision not to prosecute, to reduce charges, sentencing recommendations, any type of pretrial diversion program, and the like. A victim has the right to be present during and receive a transcript of any criminal proceedings. A victim has the right to a final disposition of the criminal proceedings free from unreasonable delay. So we've heard some conversation about making sure that the victim doesn't have to wait forever for this process to move through. And so we have language that speaks to that. And so the statute specifically says that when a court is determining whether to grant a continuance throughout the process, they've got to give consideration to whether such continuance will unduly prejudice the victim. During court proceedings, victims are entitled to a separate waiting area from the defendant, relatives of the defendant, defense witnesses, to the extent that it's practicable or possible. And if it's not, the court has to take steps to keep the contact as limited as possible. A victim has the right to be present when any plea agreement is presented to the court. So the statute provides that the court cannot accept a plea unless the prosecuting attorney advises the court that before requesting the plea, reasonable efforts were made to confer with the victim, including to provide the victim notice of the plea proceeding, when it was going to occur, where it was going to occur, and kind of what the terms of any agreed sentence would be under that plea. The victim has a right to know the date of conviction, acquittal, or dismissal of the charges filed against the defendant, and prior to sentencing, the victim has a right to notice of whether a pre-sentence report has been completed for the offender, who is completing that report, and also that the victim has a right to view that report. A victim has a right to submit a written impact statement or make an oral impact statement to the probation officer for use in preparing a pre-sentence report, and to present an impact statement or other relevant information during any plea, sentencing, or restitution proceeding. A victim has a right to receive information regarding the release, escape, death, and sentencing related to his or her offender, along with information on the status of any post-conviction court review or appellate proceedings. Working with the prosecutor, the victim has a right to have any of their property that was taken during the course of the investigation for investigative purposes, to have that property returned, and if it's not possible, if it needs to be withheld for evidence reasons or for other reasons, the victim has a right to an explanation as to why. And finally, the last item that I'll cover is that upon request, a victim has a right to be notified that he or she may submit a written statement or audio or video recording for consideration prior to the offender's release from prison or during the process of any consideration for parole or a pardon or anything like that, including change in custodial status. It's also important to note, and it's been mentioned today, that any of these rights under current law can be invoked by the prosecutor. They can also be invoked by a lawful representative of the victim, as that term is defined in the code. And so in instances where the victim is physically unable to do so, or is a minor, or for any other reason, well, for the limited reasons set forth in the statute, rather, that person can kind of step in on behalf of the victim. I know that's a lot. It's not everything that's provided. You see that the Crime Victims Bill of Rights is quite robust, and so I've tried to just cover the high points and maybe even weed out some that have been mentioned several times today. And it's important to note also that what I just discussed is in addition to the 40 or so some odd code sections that talk about victims assistance coordinators, restitution, the Crime Victims Compensation Act, the statewide automated victim information and notification system. There's also an address confidentiality program for victims of domestic violence, stalking, and assault. So what I've discussed is in addition to all of the protections, primarily resources, that are available under those additional code sections. With respect to, there's been several comments about the reasons why the existing framework is inadequate. And all I'll say is that certainly no system is perfect, but I think we will all agree that the people who have dedicated themselves to the cause of justice, law enforcement officers, prosecutors, judges, that they want to, and they'll do everything they can to honor those rights for victims. I think we can agree that the intentions are there. And so there may be instances where training or education can be used to potentially either fill gaps or step in where there are potential enforcement issues, or where there are instances where there's perceptions of certain provisions of this that aren't being honored in every circumstance, and I can't speak to whether that's true or not. But I do think that it's feasible to say that education and training could go a long way in potentially resolving that. Our office has another division that's dedicated solely to training. We train prosecutors, we train judges, we train law enforcement officers, advocates. We even train first responders and nurses with respect to certain sexual assault screenings. So to the extent that training could serve as a reminder or point out what the requirements in the statute say, our office would certainly be happy to help out in that endeavor. Overall, though, I think that our approach to serving victims has to be ever evolving. And so to the extent that we discover gaps that leave the needs of crime victims unmet, I think that we certainly should provide thoughtful and thorough resolutions as often as possible. So, Mr. Chairman, that's all that I have prepared, and I appreciate the opportunity.
Thank you very much. Would you please cite the Mississippi Supreme Court case you referenced?
Certainly. It's Payton versus State, 266 Southern 3rd, 630, 2019 Supreme Court case.
Thank you very much. Does the committee have any questions for Mr. Williams? All right, well, thank you very much.
Thank you, Mr. Chairman.
And that's going to wrap it up. Nobody has any comments? We are adjourned.